Good evening, chat. Hello. Welcome to Saturday night. We are doing Destiny's response to Pxie's lawsuit. This is his answer. This is what his attorneys file. You get served the complaint. You have to provide an answer. You have to respond to the complaint. Now, sometimes you also file a counterclaim, but that hasn't happened here yet. But Destiny's attorneys did file a counterclaim, or did file an answer. And we're going to get into that very shortly here. So, guys, welcome to the show. My name is Sean, also known as Potentially Criminal, also known as a penny lawyer to Destiny, and also known as a fat guy Nick Ricciardi yelled at to Mr. Medicare. If you'd have told me when I started doing this that both Destiny and Jim Medicare would know who the fuck I am, I would have been like, nah, ain't happening. And I'm like, yet here we are. So it's truly a humbling experience. I will save you guys the idea of this isn't a end of the world thing. Destiny doesn't come in here and, prone himself out and say, yes, I surrender. No, he doesn't. He's going to fight this, at least for the time being. So if you guys were expecting him to come in here, just, like the word that Shawshank says, he's like, I did it. Yes, please arrest me. It's like, no, that's not happening. That's not going to happen. If you really thought that was going to happen, I don't know what to tell you. But that is not happening. Okay. That is not happening. But we will go through the filings here. And we will compare it and contrast it with what Pxie alleged. And I think if you guys have I don't think, even those of you who've been here for a long time on my channel, we don't normally go through these at an in-depth amount to help you guys understand what's going on. I think this is actually a really good one to get into as far as how do you address and respond to an actual complaint. And I know some people are on the internet were saying like, oh my God, this seems like it's a bunch of bullshit. No, his attorneys have responded properly. And we're going to discuss why I don't disagree with how they did some of it. I think there's some things they did I don't know if I would agree with. But once again, that's their choice. They're allowed to do their case the way they want to do it. I would just do a little more of a, belt and suspenders type idea here, but we're going to get to that. Oh, we already got 256 people. Wow. That's a lot of people. It's a willing people. Jefferson Post says the delicious coping and seething on Destiny's part is plenty of catharsis for the moment. Well, there is that too. There is that. Yes. It's the Saturday night penny law stream. Yes. It's legal advice worth what you paid for, chat. And for all of you, it's nothing. Your super chats are tips. Code's Great Ethan Ralph, which means it's tax-free. Real quick, we got a couple. EDW Raptor met the goal. Yes, guys, if we met the goal, Destiny would leak your picks. And EDW Raptor for $20 says, well, looks like Destiny is leaking my picks. Well, there you go. You wanted this. How come? And that Chugi Show, how you doing? Is saying late, and so it would late, and so would you if it happened to you. Oh, I was making sure Rumble was up because, guys, we are on Rumble. We are everywhere tonight. We are on Rumble, we're on Twitter, and we're here on YouTube. John Coleman for $5, thank you, is saying, great, Medicare and Destiny know you. You're famous. Just don't partake of the booger sugar and slobbing on the knob. Well, don't worry. I appreciate that. I will stay away from those. Stephen Cooper says, for $2, this super chat is a retainer. And I know you're saying that, but I will just include the disclaimer that is in the description below. Nothing here is to be considered legal advice. Nothing here is the formation of an attorney-client relationship. The only way I would form an attorney-client relationship with you is through formal retention and formal engagement. You should always, if you don't have a signed letter of agreement or a signed retainer agreement, you should verify with any attorney you're working with that they actually are retained by you. And then That's a Shame says, an awful lot of people here for a Saturday night. Nerds! Yes, you're all nerds. And we're here. So Granola over in Rumble is saying, will Destiny be able to form a reply that is less than 11 paragraphs in length? Remember, this is not him. This is his attorneys. And before we get too far, we are going to just kind of fire up Pacer here so you guys can see what's going on. Now, remember, at the beginning of this, I said Destiny did not. And guys, if you aren't aware what Pacer is the online way. It's the electronic filing for the federal court system. So for the courts of appeal, like the circuit courts, district courts, everywhere, Pacer is there. This is what you use. And you can go to Pacer. Pacer's where is the actual? You go to pacer.uscourts.gov, and you can actually log in and search federal cases. So if you want to see how, I know people use Court Listener, but if there's ever a case and Court Listener doesn't have it, and you can't get the docs for free, you go on to Pacer, you can find it. You can find all kinds of cases. You could go onto Pacer and you can look up all this stuff. And Pacer is the public access to court electronic records. So the way this works is you have to figure out which district court you're in. And in this case, we're in Miami. So it's the Southern District of Florida. And then you go in there and you go into the query part and you type in the query and you type in the party names. Or if you have the case number, you could do it that way. So if you happen to have this, you can go online into Pacer and type that in and it'll tell you where to go. Now you have to be careful, because there might be another federal court that has a similar case number. So you have to know which court you're in. Now, this is the case of Doe v. Bunnell, and it's Jane Doe, and obviously we know that's Pxie. And she had her attorneys right off the jump. She's got 2 Florida attorneys there. And the defendant, Stephen K. Bunnell II. Now, his attorneys did show up, and we did see here, chat. So if you guys want to see this, down here it talks about the complaint being filed. The complaint was filed on February 18th. And that was the day Destiny knew this was out there. We all learned about it. I covered it the day it happened. So we all knew it was out there. Destiny knew he was being sued, but he hadn't been served yet. And until you're served, the clock does not start ticking. So Destiny did end up getting service. And through service was done by a process server. And that process server did bring up, and here's the other thing for Pacer, guys. If you do stuff, you got to pay for it. It's 10 cents a page. So this is a return on service. And if you guys have never seen these before, this is what happens. So what happened here? Well, Kaplan & Kaplan is a process serving company. And what do? Well, they serve court papers. So if you guys have ever watched Suits, you've ever watched any of this stuff out there, that's what you do with it, and you give it to a process server, and they say, are you Stephen Bunnell? Yes. Okay, well, you've been served. So through these process servers, they have one of their guys go out, and process servers nowadays generally wear a body cam to show the affected service. But if you've ever watched Pineapple Express and all the other things out there, process serving is an actual, at times it's a sport. And you have to be very creative and very sneaky if people are dodging you and ducking you. You know, you might show up dressed as someone else and you say, like, I got a takeout order for so-and-so. Bam, served them. You know, you have to get it to them. You know, if you guys have heard the stories of like process servers throwing it at the person to catch them and hit them with it. Yeah, at times that's how it used to be. And that's times where it's done to be official. So what happens? Well, Kaplan & Kaplan process servers on the 21st day of February, they were given it. So it took a couple of days. And they say that Henry Pinto does hereby affirm that on the 24th day of February, he did individually and personally served by delivering a true copy of the summons in a civil action, the plaintiff's motion to proceed under a pseudonym and for a protective order. So this is the entire thing. And the complaint with the date and our initials there and what happened at the address. And this is apparently Destiny's address. 1504 Bay Road, Apartment 212, Miami Beach, Florida. So, and he says that I certify I'm over the age of 18. I have no interest in the action. That's the big thing when you serve people. You can't have an interest in the action. So if you sue your neighbor, You can't walk over and go, here you go, Frank, I'm suing you. It has to be an uninterested third party. There are ways, in Ohio, for example, as an attorney, I can effect service anywhere within the state of Ohio. So I could serve papers of any kind. If I was retained by a client and we're suing neighbor Frank, I would not go do that myself either. You could have the sheriff go do it and we would pay for the sheriff to go do it. Or you would serve the neighbor Frank through a process server. And that's the other thing. Or you could appoint someone to be a process server. So if cousin Bob could go do it, cousin Bob could do it. It would save you a couple $100. If Destiny, and in Destiny's situation, if he had attorneys at the time, you could simply contact those attorneys and they can receive and accept service on his behalf. So that'll happen where I get a call and say, hey, are you still representing, Bob? And I say, yes, I am. Well, I'm representing Frank. We're going to actually file a suit instead. Will you accept service? And for the sake of, ease of things, like, yeah, fine, I'll accept service, and you go forward. So it could be anybody that does it. And it's under the penalty of perjury. I declare that I've read the foregoing, and it's true, and that I'm a certified process server. And that's an actual thing you could do, that you get certified, you understand the rules and what's going on. The way you might handle things in a local court is not how you do it in federal court. In federal court, I would recommend using a process server, just because that's the safer way of dealing with it. You can also have the marshal serve people at times. And he did point out that they were served, and this is the guy who did it, Henry Pinto. And this is the job number they had, and this is where he works out of, and this is what he did. So the service was for Destiny on the 24th. So a couple days later, Destiny got it. But if you notice, time goes by. The quote, Madonna, time goes by so slowly. And what did we see? Well, time goes by. So the 24th, and we look on here, the protective order was signed on the 20th. And in between that and the 27th, right in here is when Destiny got served. Okay. So 24th. So already Destiny knew from the 18th, the 19th, the 20th, the 21st, the 22nd, the 23rd, the 24th, the 25th, the 26th, the 27th, the 28th, the 1st of March, the 2nd of March, and then finally the 3rd of March. The 3rd of March. 2 weeks. 2 weeks. Remember, he said he had this very aggressive legal team. For 2 weeks, they were just gone. For 2 weeks, they were just gone. They didn't make an appearance. Until the 3rd. Until the 3rd. Until the 3rd. And until the 3rd. So what happened at that day? So, you got Robert Raskoff, Patricia Patino showing up. Destiny finally got counsel. So they are appearing pro hoc vice. They are not attorneys around. So I'm not going to say I was right, but it sounds like I was right that Destiny did not have attorneys to start with. Now, that doesn't mean, I still think he didn't, just given the way that all unfolded. The time is of the essence. If this woman is destroying you, you want to respond immediately, crush her, and take care of it. Well, he fucked around for a little while, and I'm sure he was trying to find attorneys. And in the meantime, he handled that, PR complaint and did all that shit himself. I still don't think he had attorneys. I'm willing to bet he didn't have the attorneys. That's the thing. Like, there's no way I would think he had attorneys there. So from the 24th, Destiny had 21 days to respond. And his attorneys did file a response. And his attorneys are an interesting group of people. And I'm not saying that they're bad or evil people. But he does have a group of attorneys here that are working for him. So he's got a couple of attorneys here. And the first one's Robert Raskoff. And then he's got Patricia Patino. And they both have Florida bar numbers. But then you have Andrew Bretler. And you have Jake Kamara. Andrew Bretler is the attorney who's represented a lot of people, including Prince Andrew. Yes, that Prince Andrew. Danny Masterson. Brian Singer. He's represented a lot of people in the Me Too situation. He's actually, and you might say, well, some of those people got burned. It's like, yeah, but Danny Masterson, the facts are bad. The facts are bad. So Andrew Bretler has experience in defending these types of cases. He has experience in these types of things. So it's something to consider that he's got pretty high-powered legal counsel. He didn't just get a penny lawyer. He got a dollar lawyer. But these attorneys did put together a answer. And at this point, the way this works, you have to file your answer. You have to file basically response. Now, if you want to file your own charges against somebody or your own claim, and you want to say, no, it was you who committed a tort against me. You want to go, no, you would file what's called a counterclaim. That is not here. In fact, all we see right now is an answer and an affirmative defenses. We'll get to what affirmative defenses are in a second. But we are going to get to this answer here. So this is just his answer and his affirmative defenses. If you're in Alabama, there's tornadoes. Guys, be careful out there. The South is getting shellacked really hard. Also, Arkansas, Missouri got shellacked last night really bad too. So be careful out there. Be careful. Now from here. Let's see. All right. Wow, you guys are chugging along here in chat. So this is defendant Stephen K. Bonnell buying through the undersigned. Counsel answers to the complaint filed in this action as follows. The nature of the action. And they say deny. Now, is there anything wrong with that? Well, we have to go back. What did Pxie say? What did Pxie say in her lawsuit, in her complaint? So this talks about the nature of the action. Paragraph 1. And this is how you do it. If it's broken down, you respond with similar breakdowns. So this whole thing here, this action seeks to hold the defendant accountable for his unauthorized, intentional, and lawful disclosure and dissemination of images and sexually explicit videos of the plaintiff. Right there already, you're going to deny this. If I'm Destiny, we didn't do that. It wasn't unlawful. Deny. That's all you have to do. You just say, deny. No, that's not true. That's all you do. You say right there, this alone. This part here. And chat, this is the interesting thing I think you guys need to understand when you're looking at this. If there's only one part of a sentence in this entire thing that's not true, you can deny the entire thing. If you guys go through when we covered lawsuits, you see a lot of times you have very well entitled things. And I try to do this when I've put together a complaint. If you're going to make a statement, fine, but boom, 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 boom. You don't just go like a big thing. You could break this down. Like, could this be 3 or 4 paragraphs? Sure. It doesn't have to be one. The problem is when you do this as one, if you could deny any of it, you deny the whole thing. That's your fault for drafting it the way you draft it. So right now they deny the whole thing. Denied. And that's perfectly legitimate. Perfectly legitimate. You guys are being ridiculous out there. Now they talk about paragraph 2, response 2. The corresponding paragraph, the complaint states a legal conclusion to which no response is required. Well, what did Pxie say? Well, we go back to here. The plaintiff brings his claims pursuant to the Intimate Image Protection Act. And they talk about all the things here. Yeah, I wouldn't even argue this is a legal conclusion, but yeah, this doesn't require a response. Perfectly fine. Now, jurisdiction and venue. So jurisdiction and venue. He deny. There's only 3 paragraphs in that. So let's look at them. So jurisdiction and venue. They're saying the court is subject matter jurisdiction under 28 U.S.C. 1331 because this action arises under the United States, including 15 U.S.C. 6851, the Intimate Image Protection Act. Well, ultimately, and I'm going to kind of spoil this, they're saying this is not a correct. This law does not apply. So, you don't want to admit, no, you don't have jurisdiction. You can't say we agree with what they're saying, because when you admit, you're stipulating to that being true. So no, we're denying the jurisdiction here. The court has supplemental jurisdiction over the state law claims because they arise of the same nucleus of operative facts as the federal claims. Well, once again, this is where I think they're getting to the point of we're not agreeing to shit. And also, if we think the federal charge is not correct, then the court has no jurisdiction. So we're denying again. Now, you guys might say, well, these are pretty concise. Yes, nice and broken down, nice and easy. But it's not working here. It's not working. So they say venue is proper pursuant to 28 U.S.C. 1391 because a substantial part of the events or omissions giving rise to the claim occurred within this district and he's subject to personal jurisdiction. Well, no, we're not agreeing to that. How the fuck do we know that happened here? There's no proof it happened here. One, and number two, we're not agreeing to shit. And to be fair, guys, I have dealt with attorneys where your response, their answer back is just deny. Like they like have Nick's favorite word, deny, all the way through, almost to the point of the defendant in this is named Bob Oberson, and they go deny. That will happen. That does happen, chat. So these are okay. Now the parties. We get to the parties part. So in the parties here, the parties for number 6, this is an acceptable answer. You can admit, deny, or you're without knowledge. So they lack knowledge or information sufficient to admit or deny the allegation in this complaint. And on that basis, we have to deny it because we don't know the fuck, Now, this is what they'll say. We'd have lacked knowledge or information, so we deny it. Well, what are they doing? Okay, so are we denying it? Yeah. Because Jane Doe is a citizen of the United States. I don't know that. We don't know that. It's a resident of Miami-Dade County, Florida. You said she's operating under a pseudonym. I don't know who the fuck it is. She's bringing this complaint anonymously due to the intimate and sensitive nature of the materials for which the subject matter of the complaint. Now, they might disagree with this part here, but remember, the whole thing, we don't fucking know. We're denying. Defendant Stephen Bonnell is a citizen of the United States and a resident of Miami Beach, Florida. Well, they get to that one, and they do say we admit except to the misspelling of his name. Okay. So in this case, they did Stephen instead of Stephen. PH. There's no V. There's a V, not a PH. But they say, yeah, other than that, yes, we actually agree with that. He is who he is. So now we move on to the factual allegations. Number 8, they deny. Number 9, they lack knowledge or information sufficient to form, to admit or deny the allegation. Number 10, they deny. Number 11, they lack information or knowledge sufficient to form a belief. And on that basis, we deny again. The defendant notes the videos were recorded at the plaintiff's request. Now, this is where you can answer partially and not partially. So we're going to cover 8, 9, 10, and 11 here. So Destiny's saying a bunch of this is bullshit, But he is saying but for the record, she asked me to record it. So there you go. Now, this is the thing here for Destiny. So he denies 8. Number 9, we don't have any information there. Number 10, we deny. Number 11, we have no information sufficient to form a belief. Therefore, we deny. And then, but also, she told us to record it. Okay, so Pxie said to record it. Now, here's where you get to Benel, also known as Destiny. It's a live streamer and commentator. Now, here's where you could deny. Does he have over 840,000 subs on YouTube? Maybe he has less. He has a huge following on X, Kick, Reddit, and Discord. Well, what does that mean? There's over 700,000 followers on his Twitch channel. I don't know what that means. But here's something they could say due to hateful conduct. Anything in here, if they determine that's not correct and they believe it's not correct, they can go deny. We're not answering it. So plaintiff known online as Pxie is also a live streamer as well as influencer. Like, they're like, oh, we don't know who the fuck she is. And, they say she's Pxie, but like, I don't know. She has 15,000 followers on X and Twitch. She has 10,000. They're like, they're like, how the fuck do we know? I don't know. Maybe, sure. We don't know. Now they talk about number 10. That Pxie began conversing with Destiny at a time when she was 19 and Destiny was 33. They're going to deny that, as they did. Now, they point out that approximately after 2 years, on or about September 12th, 2020, after multiple conversations about consent and boundaries, well, they don't fucking know the answer to that. She engaged in relations with Benel. She was inexperienced. We don't know if she was inexperienced and only had physical relations with one other person. They don't know who. I don't know. This is at the time that they had sexual relations. During this one occasion, Benel recorded videos of him and her engaging in sexual conduct. This is the one spot where they're saying, yes, it's true, but she told us to do it. The rest of this is kind of like, oh. And they could have broken this up a little bit. They could have probably broken that up a little bit. So some of you might say, well, they're going like, actually, it's like, well, no, that's actually fair. That's a fair way to answer these. Now, moving on here. Number 12, he denies. Number 13, he lacks knowledge or information. 14 lacks knowledge or information. 15 lacks knowledge or information. For Destiny, you could argue this is very apropos. He lacks knowledge and information. And then, so you have 12, 13, 14, 15, and then 16 he denies. So let's go to what Pxie said. So 12, unbeknownst at the time, Benel disseminated through electronic means one of the videos to a 19-year-old woman using the screen name Rose. They're denying the allegation. Rose was a random fan of Benel's on his Discord platform that reached out to him. Benel had never met Rose, despite knowing nothing, not even knowing her name. He intentionally shared the video of Rose without knowledge or consent. Remember, chat, he could say if anything in here he believes in good faith. Anything in here is not correct. Deny. So that's a problem when you do these bigger kind of things. Although I understand this is hard to break up into little pieces. It's hard to do that, and it's hard to break this up and that up. But that's the thing. That's how this works. And then on or about November 29th, the explicit videos of plaintiff that were shared were uploaded on the website Kiwi Farms. The video was also uploaded to other places, and this is where they could say, we don't know where it went to. Not Fans, Thought Hub, Pornbiz, Epog, and Aramy. Like, we don't fucking know. The caption on the different platforms identify both Destiny and Pxie, and her face is visible. They're like, I don't fucking know what happened. Remember, if this isn't, this is the problem when you put all this shit in there. I don't know. We don't know, so we deny. So, this is what this turns into, chat. And somebody here is making Augusto saying, they could say she was 19 years old. Like, maybe he didn't know. He just knew she was over 18. I don't know. Maybe she told him she was 20. Maybe he's got different things. Who knows? We don't know. We don't know the answer to that yet. So, 14, shortly after the video is posted, various friends and random followers of plaintiff informed her about the dissemination of the video. Some of the messages were very accusatory. Destiny saying, I don't know. And she's shocked, humiliated, and mortified by the dissemination of the video. They're like, what do you want us to answer with? What do you want me to say? 15, as of today's date, the video has been viewed on the Not Fan site over 10,000 times. And all these other sites, they're like, I don't know what the hell's there. It's been seen a bunch. I don't fucking know. And that's an answer. That's an acceptable answer. I don't know. I don't know what the hell's going on other websites. So once again, you just go ahead and put it as a question mark. You're saying we don't have no information for that. Also, chat, can you see the question marks when I put them there? I was trying to use different colors so you can see we're on different documents. When they say on the evening of November 29th, Pxie sent a message to Destiny. Expressing her horror that he shared the video of her. She asked him if he sent any of these other videos to anyone else. And this is where he admits his guilt, responding, there shouldn't be. No, I'm so sorry. There's literally no excuse. I've had phone combos and stuff with this person. They were fairly close to me. It's worthless to say at this point. I'm super sorry. There's literally no excuse. She then asked him to delete any old videos he has of her. They're denying this one. Now, they're going to deny this one anyway because this is the foundation of the allegations. They're never going to admit. Increase opacity? Okay, we'll increase opacity. There, how about that? There we go, we'll use that. Now, we move back to Destiny's response. So there's a couple more things. Going back to he lacks knowledge or information. He lacks knowledge or information. Lacks knowledge or information. 20 lacks knowledge or information. 21 lacks knowledge of information. Now, here we go. They do the whole thing about denying it, but they will say defendant notes that plaintiff's online discussions about the dispute have publicized the existence of the video, leading to more views and further debate. I don't know if I would have made that argument. That would have been that's probably not the best argument, in my opinion. Saying, well, if you hadn't told everybody that I did this really fucking nasty thing, nobody would have known about it. I don't think that's a smart argument to make. I think that's actually a very poor argument to make. That's a very poor point to concede. Once again, I'm willing to give his attorneys a benefit of the doubt here. They might have a strategy they're working on. I don't know their whole strategy. Would I ever think that's a good idea? No. But once again, they may know things I don't. Now, there's a bunch more to this, and we're going to get to that in a second here. But we're kind of doing these in chunks, chat. So we have 16, 17, 18, 19, 20, and 21. So what do these say here? Well, 17, the leak goes viral and is being discussed by thousands of followers on various platforms. Right there, they can say, we don't know. Many of the followers discussing leaks on different accounts falsely claim that she exchanged checks for personal growth and favors of Benelda. He's like, I don't know what the hell people said on the internet. It's not my job. No, I deny. She feels increasingly humiliated, mortified, depressed, and starts feeling suicidal. I don't know. On December 11th, she starts writing suicide notes. Well, he's like, I don't know what the hell she did. She says that she does message, and that's why she can say that, because they don't have to. Now, you might say, well, there are times where he's doing things, and he's allowed to do that. If he feels he can answer certain things, he can, but he can also categorically deny an entire paragraph. He has that authority and he has that ability. So already, they could say, I don't know what happened here. They also talk about her unfriending him, so she can't receive messages. He's like, well, I don't know what the hell happened, so I'm just going to once again say I'm without knowledge. On December 19th. Now, I have the feeling this stuff here, where Kyla, not so erudite, starts showing up. She's basically Destiny's henchman here. It's kind of like one of these times where, when people are making allegations, he's trying to talk her out of it. I get the feeling not so erudite is going to take this. I'm sure there's messages between her and Destiny. He's saying you need to talk to her. So, but that said, though, he doesn't necessarily know for sure what they talked about. So he could say, I don't know. 20. Where it says Erudite asked Pxie about what happened. He's like, I don't know what the hell they said. He could say that. He could say that. 21, she continues feeling depressed and suicidal. Well, doesn't know. These videos have been viewed, almost as much as 90,000 people. The majority of posts by people. Destiny doesn't know what the fuck all these people are talking about. That on other platforms, people are talking about it. He's like, I don't know. I can't answer that. I can't answer that. So this one here at 21, this is, once again, another I don't know the answer to that. Now, 22. On or about January 20th in desperation, Pxie goes online and announces Destiny shared the videos without her consent or knowledge, and that she'll be seeking legal recourse. That same day, Destiny responds on various platforms, including Reddit, Imager, and falsely claims a video leak happened without my knowledge, consent, or authorization. This claim contradicts his explicit written admission to plaintiff that he knowingly intentionally shared the video without her consent. Now remember, they can say any part of this is not true. And they're saying that. It's not true. And they don't have to tell you which part's not true. They can categorically deny it. Now, we're going to go back to Destiny's response here. So 22, he denies. 23, he lacks knowledge or information. 24, deny. 25, deny. 26, he lacks knowledge or information. 27, deny. 28, deny. 29, once again, lack of knowledge or information. 30, lack of knowledge or information. 31, lack of knowledge or information. At 32, he denies. So we're gonna do a bunch more of these real quick. We're gonna do these kind of in groups here. So in 23, what does she say? Well, 23, she says, and here it says on January 20th, right after she announced she would sue Destiny, one of his followers reached out and told her that Destiny had sent the video to her sister about 2 months earlier. He could say, oh, fucking no, deny. I don't know that. On January 21st, aware of the impending lawsuit and potential criminal investigation, Destiny starts destroying evidence. Already, you're going to deny. He's aware of an impending lawsuit. Deny. Potential criminal investigation. Deny. Deleting messages between him and plaintiff. Now, this is where they should have made this a second point. But anyways, he would deny this one here. He would have been denied. On January 23rd, he receives a letter from plaintiff's counsel informing plaintiff the intent to sue and demanding he preserve all evidence. This is critical. They should have saved this as a separate thing because now Destiny could say, deny the whole thing. But this is where if I was Pxie's attorney, anything I affirmatively did that I can document, I would have separated out. Because now this idea that Destiny, he's going to have to say, yes, we did receive a letter. And if they deny it, you can disprove that later. So that's my thing here. And this is where Destiny's attorney, they're doing the right things. This is something that does set Pxie's attorney set thumbs up. They can fix this. They can take care of this. They can do an amended complaint, actually, if they want to. They can do an amended complaint. Or they can just point out you did receive the letter from us at a deposition. And then 25. 25 is also a denial. Then on or about January 23rd, Bennell begins to publicly harass and defame plaintiff. They're going to say, obviously, we deny that. He posted his group chat called DGG with the multiple people that Pxie's just after his money. Now, they're saying deny. They're just going deny. On or about and see, this is the thing. This is where the attorney does a lot of good stuff. And he, on January 23rd, then he talks about it again on 23rd. He kind of sorts this out in a way that makes sense. Sometimes. And then other times he doesn't. Now they move on here on January 23rd. He also posts on his website. In his DGG chat, Pxie or people want money. There's no point in going after the hacker. He's probably some broke loser anyway, so they don't bother mentioning him. Well, here's the thing. They can also say, we don't know if he said that. We don't have all the documents. Now, obviously, Pxie and her attorney have receipts. But at this point, they're like, oh, if you got receipts, show them, motherfucker. We don't have to agree to that. We don't have to agree to that. Now, 27 is Destiny's attempt to blame from himself and cast blame on an alleged hacker is directly contradicted by his own explicit written admission. And they're saying that's not true. He didn't write that. You don't have any proof he wrote it. At this point, there is no screenshot attached or anything showing it's Destiny. And even if it was a screenshot, you could say, how do you know that came from him? How do you know that's his account? How do you know that is a Photoshop? They haven't done anything to lay foundation to authenticate it. So at this point, they can deny this because there is no proof being offered. It's an allegation, so you can deny it. Destiny continues blaming and defaming and harassing plaintiff on his website and in the DGG chat. He implies that she's trying to milk him and that she can't milk as much money out of that target, the other people. Over 1,000 people have seen that post. Well, at the very least, they can say, well, we don't know shit about this. But more importantly, they're accusing him of a specific act. So they're just going to deny the whole thing. And they are just denied. And that's, once again, an acceptable way. Also, you guys, the light yellow, this should be a little easier to see. Now, we'll go back over to, we're going to keep going here. In or around the end of January, approximately 15 women reached out to Pxie to tell her they received images from Destiny of other women without their consent. How the fuck does he know what happened? He doesn't know. He wasn't there. He doesn't know anything about it. He can easily say, I don't know. Upon information and belief, multiple women, including Melina and Stasia, have recently come forward and alleged that Destiny has released videos of them without their consent. And they were then posted to different pornography websites without their consent. He's like, I don't fucking know. He's like, how do I know these people are who they say they are anyway? How do I know any of that? He doesn't know any of that. So he can say I'm without knowledge, therefore I deny. Then he could say a woman with the name Sherry recently found out that Destiny had made an unauthorized recording and then distributed it to people without her knowledge. And they say that he's retaliated against Cherry by posting private messages during a time when she was suffering a mental health crisis. Now, he could say, I would have just denied this, but they could, they're saying instead of denying, they're like, we don't fucking know who Cherry is. How do we know that's Cherry? How do we know anything in that audio? They're saying, we don't know. I would have just fucking denied that 100%. But then it kind of gives the idea you might know if it's not Cherry, if it's not correct, then who is it? So there is the idea that, by denying, you are opening yourself up to an issue there. Once again, they know more than I do because Destiny's probably had to talk with them. It says, on or about January 23rd, Destiny begins a smear campaign against a plaintiff. It tells his followers that she's only interested in getting money from him. Over 1,000 followers saw the post. He also tells followers his only crime was being too much of a gooner. And they're saying gooner is slang for someone deeply engaged in X-rated content consumption. Now, it'd have been funny if, in this case, Destiny comes back to this one and he says denied. Now, it would have been funny if they said, we deny that, but we do agree with the definition of gooner. They didn't do that, though. They didn't do that. They didn't do that. But this is an acceptable response. Now, we move on to 33. Destiny says, I like knowledge or information. 34, 35. The rest of them, deny. Denied. All of it's getting denied. So they're allowed to say that. They are allowed to say that. They are allowed to deny everything. So we'll get the last of these, and we'll get to the allegations here. So 33, what do they do? He's gonna deny it. 33 is without knowledge. He says, on or about January 24th, another streamer talked about Destiny sharing the video. She informed followers that Destiny recorded a video conversation without her knowledge or consent. Well, number one, we don't know who this other streamer is. So Destiny can already say, I don't know who the fuck you're talking about. And then later posted his followers that he could take it down. Then on 9th, after posting a link of her talking about the video, He retaliated by posting your private messages between them and his community chat group. And he's just been like, I don't know. You don't have any information to know this. And then 34, Hannah Brooke, a follower of Destiny, contacted Pxie and said that even after the video is publicized, Destiny offered to send the videos to her. Now, because this is a specific person, he could say, I didn't do that. I didn't do that. And he can just continue on denying the whole thing. Now, who knows what part of this is true or not true? And it says, defendant has admitted he disclosed the video to Rose. There are documented logs, but that doesn't mean they've been authenticated yet. So you know what we could do? We could deny it. And there is evidence he also disclosed to other people. Remember, if there's multiple things, you can deny it all. So 36. He says here that Destiny admits he's been actively deleting evidence of wrongdoing, specifically his messages to multiple women. He claimed he shared sex videos without their consent. He's like, deny, didn't do that. I didn't talk and I didn't say all this shit. I didn't do all this shit. Remember, they can deny all of it. They can categorically deny it. Or they can specifically deny point if they want to. Then on or about February 8th, Destiny posts on X that he agrees with another post that claims she is extorting him. Then on or about the 9th, Destiny makes another defamatory post, again telling his followers that she only cares about money. He also informs all his followers the video can still be seen on Kiwi Farms. The post has over 1 million views at this date. Remember, they can deny any of it. But remember, there's no proof in here that he said this, so they can deny it. It's an allegation, so they're denying it. The videos discussed by Destiny were disclosed, were of a private nature, were never intended for public distribution. And they're going to say denied. And because remember, they're going to allege consent. And they say that they caused her emotional distress, humiliation, and harm. They're going to, like, no, we haven't. Her career as a streamer has been adversely affected, and her aspirations of office have been greatly diminished. Bullshit, and they're denying it. They're denying it. They are denying that. Now, we move on to the Intimate Image Protection Act here. So we've only got a couple of things here, chat, but we're going to get to these and see how Destiny responds. So 39, now notice his response to all of this, they adopt and restate the responses set forth in paragraphs 1 through 38 above as though fully set forth herein. 40 denies, 41's without knowledge. 42 is a deny, 43 is a deny. Now, why does he have to say that? Because, well, 39 for Pxie is saying, we adopt and rearrange the allegations set forth above. He's like, they can't argue with each other like that. So they're just like, yeah, like we're acknowledging our own other things. Now, what does he say here? That he knowingly and intentionally disclosed the videos without consent or knowledge. Okay, well, he's saying that's not true. He's going to say, I had consent. Or it was inadvertent. He says that the Pxie's identifiable in the videos. The videos have been viewed by thousands of people and continue to be viewed. The leak of the videos and have been discussed online by thousands of people. He's going to say, I don't know. He's like, I don't know what these videos are. You haven't shown us any evidence, so I'm without knowledge. Deny. As a direct result of the conduct Destiny did, she suffered emotional distress. Deny. So obviously, if you admit you did that, then you fucking opened yourself up to, if you were to admit to all these things, then if you came in and yes, everything is true. Well, then Pxie can move forward with that. You've admitted to all the allegations. Hold on here. Bamalot saying, does federal court allow for blanket denials? Yes. And J-Rock, yes, you brought it up here. Yes, under Rule 8 of the Federal Rules of Civil Procedure. And we'll just bring this up real quick. Remember, Chad, I've talked about this before. When you do stuff, criminal law, civil law, you're governed by rules of procedure. And there are a whole set of rules. And when you talk about pleadings and motions, how do you respond to things? You go to rule number 8, the general rules of pleading. So you talk about defenses, admissions and denials. So what does this say you can do, what you can't do? And it says, in general, In responding to a pleading, a party must state in short and plain terms its defenses to each claim asserted, admit or deny the allegations asserted against it. And it says in denials, the denial must fairly respond to the substance of the allegation. Okay, well, if you're not clear on what's there, yeah, they have to deny it. Remember, they have to deny it. So they're working off of what you gave them. They're only responding in kind. But then you have general and specific denials. And it says a party that intends in good faith to deny all the allegations of a pleading, including the jurisdictional grounds, may do so by a general denial. A party does not intend to deny all the allegations, must either specifically deny designated allegations or generally deny all those except specifically admitted. You can deny part of an allegation. A party that intends in good faith to deny only part must admit the part that is true and deny the rest. So they say lacking knowledge or information. A party that lacks knowledge or information sufficient to form belief about the truth of an allegation must so state, and the statement has the effect of a denial. And here is the big thing, chat, the effect of failing to deny. Other than one relating to the amount of damages admitted, if a responsive pleading is required and the allegation is not denied. If a responsive pleading is not required, an allegation is not considered denied or avoided. So yes, you guys can do all of this. And that's how these are set up. And if you guys are wondering, well, how does that work in my state? Your state rules of civil procedure will be very similar. So now getting back to this, they're saying all the above actions violated 15 U.S.C. 58.1. And they're saying she's entitled to permanent injunctive relief, actual damages, punitive damages, and reasonable attorney's fees. Destiny's saying bullshit, denied, not true. You aren't entitled to fuck and or all, is her argument. So this is Oh, Bama Law saying it's been a long time since I've read Fed rules. Well, I wasn't just doing it for you, chat. That was meant for all of you. Because if he's got a question, some of you out there also have that question. And we gotta go through this together. We're trying to learn, we're trying to understand. So we move on to what Destiny responded to count 2. The violation of the Florida state statute. So he adopts and reinstates the responses above. Because remember, this is only about the stuff in 1 through, and I think they messed up here when they did this before. It says 1 through 38. Now, I think that's a typo because I probably didn't mean to do it. And if that becomes an issue, they could say, Your Honor, that's clearly a typo. And the court would say, yes, that's fine. We could fix that. But obviously, this is where the allegations and the factual basis end. So they don't have to incorporate that part here like that. But now they have to incorporate the other facts that go there. And they say that these, we adopt it. The corresponding paragraph of the complaint states a legal conclusion as to which no response is required. Remember, chat, as the rules say, if no response is required, no response is required. 46 deny, 47 deny, 48 deny. 49, we lack knowledge or information. 50, we deny. 51's a legal conclusion that we have no obligation to respond to. 52 is a legal conclusion. We have no obligation to respond to it. Now, what happens from here? We're gonna see what all this is. So for 44, it's readopting the allegation. So yeah, that doesn't matter. They say Florida statute 748.049 provides a statutorily created private right action. Legal conclusion, we don't have to say anything. 46 is the next. Oh, sorry, Chad, we got to switch over to that. This is a legal conclusion. Yeah, that's what the law says. Okay. So we're not answering it. 46, though, says he knowingly and willfully disseminated material. He's already denying all of this. He's going to deny the entire allegation. 47, he acted intentionally or with reckless disregard and caused her to suffer damages. Deny. They're going to deny all of that. 48, he shared the videos for no legitimate purpose. Deny. 49, tens of thousands of people have viewed the videos on different platforms, and they're aware of the release of the videos. And there have been online discussions. Once again, he's like, I don't fucking know. And that's fine. I have no idea what you're talking about. I don't know. I don't know how to prove that. I don't know any of the information there. So there's nothing wrong with that. There's nothing wrong with that. But once again, he's saying, you know, we also, and on that basis, we deny the allegation. We just don't know. We just don't know. And then 50, as a direct, natural, and foreseeable result of the actions of violations, she has suffered damage to reputation, emotional pain, suffering, mental anguish, and all of this. Well, as a violation of the law, this is a legal conclusion. We are not required to answer. We don't have to answer. Now, this is where, in J-Rock, you're bringing this up. Yes, this is where you need to add anytime you feel that you don't have to respond. Let's say you get into court and the judge says, actually, you should have responded. Counsel, you were wrong. You should always say, in any case, if a response is required, we deny it. So the judge may look at that and say, okay, yeah, it is a legal conclusion. You don't have to answer. Or if the judge says you're wrong, oh, you did deny it, cool. So therefore, you haven't admitted to it. I don't think that's going to be an issue here for Destiny. But that is something that could happen. But he does not include at the bottom here. By the way, if we're wrong, we deny. And that's where he should have said something here that J-Rock's talking about. And that's not a bad idea. It's never a bad idea. But once again, these guys are doing their thing. I mean, these are not first-year attorneys. They've done pretty competent things. I've never heard of them getting burned on things. So they might have a strategy. They might know some ins and outs of the Southern District of Florida. They might have talked with people who have been there and who work there and told them, you're cool, don't worry about it. I don't know. We don't know the answers to that. So, like I said, they're doing their thing. I would not do it this way, though. They're saying she seeks injunctive relief. Well, that's a legal conclusion. And she seeks statutory damages for all the things that have happened here in an amount of no less than $1 million. Legal conclusion. We're not dealing with that. And then once again, you have this readopting and alleging the allegations. Well, we're not dealing with that. That's not ours. And so, guys, we're already on to count 3. So count 3, Destiny adopts and reinstates the responses here. Travion Washington says, so if the alleges need denies, is it a matter of fact for the jury to decide? Well, it's a fact in contention. And that means that summary judgment isn't something you can do, because summary judgment means there are facts in contention. Summary judgment would imply there are no facts in contention. And that just shows the court that there are issues that are going to require discovery. But anyways, when it comes to count 3, deny. They go the full. He does the full ricada here, chat. The full ricada. So 54. His conduct was either done intentionally with reckless disregard, or without her consent. Nope, denied. He acted in a way which he knew or should have known that emotional distress would likely result. Denied. The actions were so extreme and outrageous. Remember, chat, it's outrageous. They go beyond all bounds of decency and are intolerable. Denied. Nope, we're not agreeing to that. Even after he became aware, he continued to disclose the videos to other people without consent. Deny. No, bullshit. We didn't do that. And that's what they're saying. He's saying, fuck you. We're not saying all this. And they're saying, and now it's interesting. Because this one here, 58, seems like another one with a legal conclusion. But now they just said deny. Now, and this is where it's interesting, because this is basically a legal conclusion, and they didn't cite this as a legal conclusion. I think that they might have had different people working on this complaint. That doesn't mean they're toast, but you can see that thing we were worried about, they didn't do. But now they're doing it. They denied. 59, denied. Local admin says, please tell me you have a recap for all these Pacer docs. What do you mean, like a written recap? I'm not sure what you mean there. So, we're going to move on to count 4. See, chat, we're almost already done. And look, we've only been doing this an hour. We're almost all the way through it. Count 4, invasion of privacy. We adopt and restate the responses above. And you notice, guys, they kind of jump around. So in this one, they do 1 to 52, the responses. This one's 1 through 34. They skip an entire thing, and they still miss part of it. So this is where I think there's kind of like a little bit of sloppiness. But here's the thing. This is where we all fuck up as attorneys. We all kind of forget things. We're putting stuff together. So that's why I'm not bagging on these guys. These guys are highly competent attorneys. Like, you fuck up filings once in a while. But in this one, in count 4, they're talking about all 59 paragraphs before it. Count 3, they talk about the 52 paragraphs before it, 1 through 52. And then count 2, they talk about 1 through 34. Okay. But then you have the problem of they skip 35 through 38. And then count 1 actually says paragraphs 1 through 38. Like I said, that's not fatal. This is not a fatal thing. If people out there look at that, this is not a, oh my God, whoa, buddy. This is not one of those things. This is not one of those things. I want you to understand, this is not a panic situation. This is not a, this is not a, kill shot. This is nothing from the top rope. Look out! He's got the chair. No, none of that's happening. None of that's happening here. These are not fatal issues. These are not fatal issues. They're not fatal problems. I just want people to understand, because I'm sure people are going to run around screaming about all this like there's something going on. No. It does show a lack of attention to detail. It does show, like, are these guys on top of this? Is this a high priority client for them? It shows they've had multiple people working on this, and there wasn't, like, the guys who signed off on it didn't check the work. So yeah, there are things this looks bad for, but is this still filed more competently than the Barnes Walker in Nick's case? 100%. That's why I'm not going to sit here and bag on these guys yet. I'm not going to bag on them yet. So we're going to move on to count 4. So count 4, Destiny goes deny. And what does he talk about here? Well, the invasion of privacy. Well, once again, they don't have to answer 61. He disclosed private facts concerning Pxie that were not of legitimate public concern, and without her consent. Deny. I had consent. There's no public concern that justifies disclosing images without her consent. Denied. I had consent. At all times, he acted with reckless disregard. Denied. He could or should have expected public discourse to arrive from these videos. Denied. Destiny's going to plead, I don't know, I'm just tired. So the public disclosure would be highly offensive to any reasonable person, including the plaintiff. Denied. How did fuck? I don't know. She consented. 66. The videos took place with such that people are aware of this and of her role in it. Denied. She had a reasonable expectation of privacy in the videos since they were taken for private use. Denied. He's going to say that she gave consent. Such disclosure to cause humiliation, distress, and emotional suffering. Denied. We're denying the whole thing. Now, you don't have to respond to the prayer for relief, chat. You can come up with your own prayer for relief. Yes, he could try the Russell Greer argument of, Your Honor, I'm dumb as shit. Which he might do. He might do. He very much might do that. Now we move on to affirmative defenses. Guys, affirmative defenses are defenses where you sit down and tell somebody, look, yes, I did it, and I have a really good reason that you can't do anything about it. And that reason protects me from legal recourse. So the first one, and you guys do not laugh at this. This is an actual argument to make, though. The first affirmative defense is a lack of subject matter jurisdiction. The court lacks subject matter jurisdiction over the claims in the complaint. Well, remember, they denied that they have jurisdiction under federal law because there's a federal law involved. They're arguing that's an affirmative defense, and that is an effective one. That's an effective defense. Your Honor, this court isn't the proper venue because this isn't a federal issue. The second affirmative defense, consent. This is 100% a defense he's going to do. At all times, she gave her consent expressed. Now, this is going to be an iffy thing, implied. That's going to be kind of iffy. To the acts, omissions, representations, and courses of conduct of this answering defendant and this complaint, and in each and every allegation in the alleged cause of actions. He's saying, I had consent, therefore it's your fucking fault. You know, you gave me consent to do this. Now, these other defenses you're going to see, chat, these are boilerplate affirmative defenses that you include. Because if you don't raise them now, you can't raise them later. So the failure to avoid harm and exercise due care. Now, might they argue that by her going and talking about it, she exposed more people to it? I could see that argument being made, possibly. But you raise these just in case because you don't know what discovery is going to bring up. So the recovery should be barred because she unreasonably failed to avoid harm and exercise due care. That it's her fault. She failed to avoid the harm and she failed to exercise due care. Kind of that you assume the risk. It's your fault this happened. If you hadn't been such a retard, this would have happened. The fourth affirmative defense, there's no damages. You suffer no damages as a result of Destiny's actions. You know, the fifth affirmative defense is failure to state a claim. Now, this is an interesting one. This is an interesting one because we're going to go back to this chat, and I think there's a problem here, and I don't practice in the 11th Circuit. J-Rock, you do, and I didn't get a chance to ask you this. So if you're here, tell me about this. The failure to state a claim upon which relief can be granted. Rule 12b-6. The complaint fails to state facts sufficient to constitute cause of action against the defendants, including because the conduct alleged precedes the enactment of 15 U.S.C. 6851. The way this is being argued here, I think that they're trying to argue that that's applying to all of it, but I think this is very sloppily written, in my opinion. They could have probably wrote this a little better. I think. But he's trying to say all the other claims, they failed to state a claim upon which relief can be granted. And this precedes the enactment. In this case, also precedes the event precede the enactment of the federal statute. I think that could have been worded far more effectively, saying you failed to state and constitute a cause of action against me on counts 1, 2, and 3, or counts 2, 3, and 4, and then also include count 1. But J-Rock, I was going to ask you. Oh shit, you guys haven't seen it. I'm sorry. Sorry. I thought you guys saw it. Okay, so the first affirmative defense is lack of subject matter jurisdiction. The court can't hear this if there's no federal cause of action. Second one's consent. She gave consent. That's a pretty big thing. You know, the fourth one is no damage. Like, the third one is avoiding harm and exercising due care. It's her fault. She didn't exercise due care. She failed to avoid the harm. Fourth, no damages. She's actually suffered no damages. If you don't have damages, you can't seek action. 5 is the failure to state a claim. And J-Rock, this is where I'm trying to get to this here. I feel like they have to file their 12b-6 at this point. And I don't think this is an effective 12b-6. I don't think this is a 12b-6. I don't think it's an effective 12b-6. J-Rock, you can tell me if this is in the 11th Circuit, but maybe it is in Florida. So you're saying this is an effective 12b-6? This counts? Okay. Oh, you're saying, yep, they should have filed a motion. Okay, guys. So Rule 12b6, chat, is the motion dismiss upon failure to relief upon which a claim can... Yep, sorry. You fail to state a claim upon which relief can be granted. And we talk about this all the time, chat. These are the defenses and objections. Oh, you're agreeing with my assessment here. So these are the Rule 12. So in general, when you serve an answer, anyways, we're going to get to the actual things here. So how to present defenses. This is Rule 12b. Every defense to a claim for relief or any pleading must be asserted in response to pleading if one is required, but a party must assert the following defenses by motion: lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon which relief can be granted. Yeah, that should be done as a motion. Now, the reason why I bring this up, chat, like the 11th Circuit is different from the 6th Circuit, from the 3rd, from the 1st. They might have different intricacies of things. And then from each circuit, Florida's got its own districts. Georgia has its own district courts. Alabama has its own district courts. I think they fucked this up and they're going to lose on these grounds because they didn't properly assert this. Normally, when you file your answer or counterclaim an answer, you file a motion to dismiss. And they haven't done that yet. And I feel like they're kind of waiving that. Now, I might be wrong. And if I'm wrong, I'm willing to be wrong. And I'll be wrong on that. But just looking at this, I have a concern. And J-Rock is in Georgia. But he says here, the Fed filing a motion to dismiss relieves from having to file an answer, but the motion would have to cover all claims. And that's fine. That's fine. You can do that. But he hasn't done that. And that is a very common thing in federal court. You immediately out the gate say, motion to dismiss. This is all garbage. Lack of subject matter jurisdiction. Failure to state a claim upon which relief can be granted. All these claims are garbage. Judge, run them out. You can do that. They didn't do that here. And when you do that the first time, and the judge says, actually, they do have claims, you then are given the permission, the ability then to file an answer and counterclaims. But they kind of skipped that and they just went straight to their answer. And I don't think this is going to be effective. This could be a problem. This could be a problem. Like I said, if I'm wrong, I'm wrong. But chat, when we talked about these before, these are the 12B things. So 12B6, and there's 12B 1 through 7. And this one, failure to join a party under Rule 19. This is something that I think is going to be a problem for Alyssa Mercani because she talks about Destiny saying something and JT Smash re-airing it. Well, you should have sued fucking Destiny. So that is where we are in that. Now we're going to move back to Destiny's affirmative defenses. So I think that this is a problem. I think this is not well worded. I think they could have worded this better. But more importantly, this whole thing right here should be a separate motion on its own. And I would argue you probably should do it. If I was doing this, I would have I would have done this first and this would have all been filed. But they didn't do it. And this is a big problem. They don't have it there. And we'll go back to Pacer real quick, chat. There is an answer in affirmative defenses. There is nothing else. There's nothing else here. There's nothing else here. And this is a problem. I think that's going to be a problem for him. We'll see. We'll see. Time will tell. The 6th affirmative defense. Punitive damages are not supported. She's not entitled to recover punitive damages because the defendant has not committed fraudulent, oppressive, malicious, willful, or egregious acts. And this one's an effective one. The 7th affirmative defense, the attorney's fees are unavailable. The 8th affirmative defense, no emotional distress. The 9th affirmative defense, unclean hands. Unclean hands, chat, are an issue in equity that if you seek equity and you seek the court to do things right, this is an old doctrine that if you seek protection, you can't have come into court and acted like an asshole. You can't have been part of this. If you're seeking equity, you had to have been ethical and fair in your own actions. So this is Acer Thorne's favorite thing to claim. There are other things you can also claim: lashes, estoppel. Those are a lot of other things you might throw out there. Those are all common law defenses. and common law affirmative actions. They don't cite any of that here, but we'll get to some of the other things they do cite. Yes, J-Rock, it should have been filed before it, but I think they didn't, and I don't know what they did. I don't know why they didn't do it. And it's not like we have, going back to this chat, you might say, oh, well, it didn't get filed timely. It's like, this should have been filed first. So I have a concern. Yes, Destiny filed this yesterday. His attorneys filed it yesterday. It would have been electronic. This isn't a situation where it got mailed out. These are filed electronically, so they get put up pretty quick. So this should have been second, and he didn't do that. And I don't like that. I think there's a problem here. Now, the 10th one is speculative damages. The damages are speculative, uncertain. It's a fair argument to make. We just don't know what's out there. It's all hypothetical. And you can make that argument because right now there has been no proof to damages. There has been no proof to damages. They say the 11th affirmative defense is a failure to mitigate damages. And you have an obligation. So, Chad, I'll use an example of this. Let's say you hired a roofer to work on your house. And while he worked on your house, he just he took your money and ran off. And in the meantime, your house is completely exposed. You know, he tore off all the sheets and he tore all the plywood off your house. So you just have bare rafters in there. And you can see straight up out of your living room, and you look up and you can see the birds flying along. As let's say it's sunny right now, and you get word that a storm is coming. And it's going to be rain. It's not going to be like a tornado. It's just going to be a downpour. You have a bit of an obligation to mitigate your damages. Okay? You can't just sit there and go, oh, well, I'm just going to leave out your Picasso painting. You can't just leave it sit there and let the rain hit it and ruin it. And now it's like, oh, you owe me $50 million. No, you have a duty to mitigate damages. If you have things that need to be protected, get them under cover, move them somewhere safe, cover them up, move you have a duty to mitigate a little bit. Now, if it costs you money to do all of that, if it costs you money to come in and move all your stuff, and you have to hire a moving company to move all your stuff out of there, you can sue for that damage, but you have a duty to mitigate damages. You have a duty to not run up the scorecard just because the guy breached. You have to do something in that regard. So there is a duty to mitigate, and that is a frequent thing. You're not allowed, and that's almost like an unclean hands issue too at that point. It's also a failure to avoid harm. You could argue too. You're failing to keep things from getting worse. They're not expecting you to fix the house up, but maybe put a tarp over the hole in the roof. Or if it's something you can't do, move all the shit out of the way. Now, if you can't do anything about it, let's say you're like a 90-year-old lady and you don't have the money and nobody can help you, and the contractor left as the storm clouds are rolling in. Okay, well, yeah, now he's fucked. And you don't have an obligation to do anything. But if, let's say, you just sit there, you're like, oh, the rain's coming. Fuck it. I'll make him owe me $50 million. I'll let my Picasso and my TV and my Dale Earnhardt plates get ruined. You can't do that. You have to try to protect yourself a little bit. So, and guys, like I said, there's going to be a lot of variations of things you can do with that fact pattern, but it's just the general idea of you've had a week to prepare and it's been sunny every day and you don't do anything to prepare. You fail to mitigate the damages. So you're under a duty to take all reasonable action to minimize the damages alleged in the complaint. She failed to comply with the duty and is therefore barred from recovering. And they say that the 12th affirmative defense, damages are not proximately caused by Destiny. And here's the thing. This is where you're allowed to make an argument here. Assuming without admitting that she suffered any injury or damage, Destiny is not liable for the damages because any such damages are not the cause of action by Destiny, by his act or admission. Remember, Destiny's saying it's the evil hacker. So you're allowed to argue in hypotheticals at this point. So. Oh, chat. Hold on, I gotta expand this more. Sorry, so you guys can see this. Now, the 13th affirmative defense, waiver. Now, the doctrine of waiver is another, once again, chat, this is another common law defense. You can do things. You can make arguments here. Like I said, there's lashes, there's estoppel, there's reliance. And by waiver, the idea is that you sit there, you didn't do anything. Typically, like a waiver is if you sit on your hands, you've waived your right to take action. The fact you didn't do anything about it shows that you waived that concern. Now, who really knows? Let's say she learned, and I think, and here's a hypothetical, for example. Let's say Pxie learned the day after Destiny did it, back in 2020, when these allegedly got leaked. Okay. And she said, oh, fuck you, Destiny, you're an asshole. And she knew they were going around and she didn't do anything about it for 4 years. And then all of a sudden, once it blew up on the internet, she finally acted. That could constitute waiver. She knew about the action and she did nothing to respond. You sat on your hands for too long. And that actually does happen. That is a valid defense. Where is... where am I looking at? Hold on here, chat. I'm trying to catch up. Some of you guys are asking questions, and I'm trying to star them as I go here. They're gone too far. Sorry, chat. I'm trying to go as I go here. My bad. Okay, Jamie Gums saying yes. Okay, Destiny is always the king of cuck bad takes. Yeah. And Hella says you can't wave if you sit on your hands. Thank you, Hella. I appreciate that. I appreciate that actually for that. The 14th affirmative defense is injury by others. So each of these is done by someone else other than Destiny and is beyond his control. And that's the hacker. The evil hacker did this. So his prayer for relief, he says they want the complaint to be dismissed with prejudice. They want her to take nothing by way of her complaint. That Destiny get awarded all costs and recoverable attorney's fees incurred in connection with the lawsuit. And that he be granted all such other relief the court may deem just and proper. And now he wants a jury trial. And it's signed by his attorneys. He's got Robert Raskoff. When they showed up, Patricia Patino. They are here. And guys, remember, for the Prohoc Pxie situation, you need local counsel. So these guys are the local people. And the people coming in out of WeHo, West Hollywood, California. West Hollywood, California. Out in LA. Andrew Bretler and Jake Kamara. They're both admitted Prohoc. Well, he is admitted Prohoc Pxie. Bretler was not admitted Prohoc Pxie yet. Let's go back and check. Did he get a Prohoc yet? No. He's not Prohoc admitted yet, but did he file a... We're going to check here real quick. Okay, so he motioned to come in. Oh, okay, so it is hereby ordered and adjudged. Okay, he did get granted Prohoc. That's what I thought, but he doesn't have it on the complaint. Although it may not have come in by the time he had it on the complaint here. They filed the complaint. Although it's weird because it was granted on, if we go back to this, it was granted on the 4th. The order got granted. And the 14th, they file this. It's like, I get it if they granted it the day before and you've already, like, shit's out of your hands. But at this point, you don't have Prohoc Pxie in your thing here. Like, there's a bunch of stuff that's a little sketch. Like, this leads to a lack of attention to detail, in my opinion. And that causes you concern, like, what's going to happen in this case? But, yeah. Why in the world not hire local Miami attorneys who know the clerks, courts, and judges? They did hire local attorneys. They did hire local attorneys. But you want the guys who are great at the Me Too shit. Like, I understand Destiny's logic here. You want subject matter experts. And I don't blame him for wanting to get guys who are pipe hitters. I don't think there's anything wrong with that. It's just, I think he didn't go about this the right way, and they haven't done the right thing here. Real quick, though, up on the Horizon saying if Picasso painted a bunch of Dale Earnhardt plates for me, I would have thrown them all in the garage. Picasso was a sicko. Well, yeah, I know. These are Me Too dudes. I understand. But if I'm in a situation where I'm dealing with shit like this, I want these guys who have handled this battle before. So, yes. So we got a bunch of comments and stuff to catch up on here, chat. Tech South guy says, what about attorney sandwich confidentiality? That doesn't last very long because I eat the sandwich. Brian Ogden says the weather in northern Ohio sucked today. And it was pretty good here except for the morning when it rained. Apparently it like thundered so hard, 2.0 was like, I slept through it. And apparently it scared Clyde really bad at like 7 a.m. But other than that, the whole day, it's been like almost 70. It was 70 and sunny over here in Cleveland. Ag says, I've been using Court Listener to follow Destiny. Yes, and Court Listener is the free way to find documents, chat. Brian Ogden saying just Uber law. It's so Uber law. Well, yeah, these guys are, Burke and Bratler they're no slouch. Keldog is a new member. Thank you for your support. Thank you for joining in. I appreciate that. I appreciate you doing your part here. To just help spread the green, making chat green again, making America green again. That's what we're trying to do here. So thank you, Keldog. And guys, tomorrow, if you guys are members, we are going to do a members only tomorrow night, tomorrow afternoon. I'm not, we got some funny stuff we could talk about, and we'll go from there. But yeah, it should be tomorrow afternoon. I'll make sure I put it up early enough for people to know. Graham, how you doing, buddy? It's been a while. Good to see you. Saying, yes, I did it, but here's why I'm still not liable. Yes, that's an affirmative defense. I did it, and I have a great excuse. And that excuse means you can't touch me. John Simons is saying, as a client with a group of super lawyers, do you talk to them individually and vet approaches and maybe even pit their opinions against each other? I don't. If you were looking for, you can do what's called, like, an attorney in the legal industry, it's called a dog and pony show. Like, you're being basically asked to come in and say, pitch us what's your strategy. Once you have a legal team going, no, you don't generally want like some sort of conflict and tension in your legal team. But I'm sure that he approached the local Florida counsel or Burke and Bratler. I'm sure the way it worked is Destiny approached the California guys, and they had contacts of people they knew in Florida, and they said, these are the people we want to use. Are you okay with that? Please go talk to them. And I'm sure Destiny's like, yeah, whatever you want to do. Jefferson Post says, concise points, so they must answer each or suffer. Yes. Irham Amin says, Destiny's damn foreskin better make it to Discovery. Well, I don't know if I really want that, chat, but I guess some of you do. Some of you do. I Hate Yankees says, Destiny tried to evade service by hiding in a shoebox, allegedly. It's funny, though, because people did figure out he was on a live stream when he got served. Because somebody knocks at the door, he gets up and gets it, and it matches up with the times on the service documents. Keopathic says, anything he doesn't believe in good faith. Dude honestly believes he's a Wikipedia scholar. Well, right now his attorneys have no reason to believe he's lying, so they can answer in good faith. Luke says, you could easily split these things into two, one covering his relationship with Rose. I agree. Just Me says, well, I'm a Kiwi and so is Sean. Well, thank you. Yes. Jefferson Post says, was hoping he'd stick with the My Cousin Vinny opening of everything she said is bullshit and just jive into the felt like he has been on Steam. So K-Dog saying, is he good? Is he doomed? Is he doomed right now? No, but I feel like his attorneys, there's some things they didn't do right, which are going to cause him fundamental problems going forward that they didn't properly assert defenses. They didn't raise proper objections at this point. I think Destiny's going to be in this for the long haul anyway, so I don't know if this is really going to affect him. But I think his attorneys did cock that up a little bit. And by a little bit, a lot. So, but Destiny's going to fight this anyway. So he's not doomed, but I'd say he's pretty boned right now. Brian Ogden says, lol. Yes, thank you. Okay, let's see. John Coleman's been a member for 11 months. Thank you for your support. I appreciate that. Says, is Florida a single-party consent state? I think so, but let me check. Recording laws. If you guys don't know, there is a... this is a great resource, and I'm just saying if you need to check. This is a great place to initially look and see it. But from what I understand, Florida is a two-party consent state. So no, it's not a one-party consent state. And Alex says, so if everything's one paragraph, which got one denial, but then it goes to court and everything is proven, is it the same outcome? Yes, but that is a problem for Pxie's attorneys. They didn't properly plead their complaint. And Destiny's attorneys say, look, yeah, we had to respond, so we responded. It's not our fucking fault. I'm gonna go. You know, their attorneys could be like Jordy on Lolcott Live, and they could put on the top hat and be like, we answered it. Let's see here. Where are we? Yeah. Oh, hold on one second, chat. Chat, give me 1 second. I have to help 2.0 with something real quick. And no, we're not going to give Clyde cocaine, although he's already hyper enough. So give me 1 second, chat. I'll be right back. All right, chat, we're back. Real quick, I forgot. Somebody did send me something in the mail. So let's see what it is. All right, chat. So Whoever sent this, you don't have a note on this, so I can't tell you thank you. Whoever sent this, thank you. So it's a model of a train. I don't. What skill level is this, by the way? What level? Is this like one of the? Oh, it's a Union Pacific. Okay. Oh, it's a skill level 3. Okay, so it's not too hard. All right. Well, thank you. I look forward to making it. Whoever sent it, thank you so very much. I do appreciate it, and we will build it. This will join the pile of shame. J-Rock did say, though, a lot of judges here in federal court have a standing order. You repeat the allegations and your answers and specifically respond to each of them. And guys, remember, I've said this before. You have like your foundational rules of procedure for whatever issue you're on. And then you have, rules of evidence, rules of this. And then you have local court rules. So for the courthouse, there might be rules that all the judges agree on. And then each judge, and in federal court, we talked about this with the Alyssa Mercanti case, the JT Smash case. In the Eastern District of New York, each judge has a specific set of rules they follow, and you have to do. So knowing your local rules is critical when you're practicing as an attorney. Makes you look like not a fucking idiot in front of the judge. And God forbid you ever need like the judge to give you some leeway, and he might give it to you. Like you're kind of like there's an issue where it kind of teeter-totters. The judge might side with you because you're not acting like a shithead. Fred Rush, he's been a member for 7 months, says, were these girls even hot? No, they're a bunch of BPD hoes. And thank you for the support, by the way. Thank you for the support. All right, here. Chet Manley says, is there any problem with Tiny denying these things when he talked about it as manifestos or on stream? Well, remember, this is all for Pxie to prove. All for Pxie to prove. It's all for Pxie to prove. And local menu said, tell me you have a recap for all these. If you go on the court listener, you could type in Doe v. Bunnell in the Southern District of Florida. It should pop up. But if you need something, email me, potentially criminal. I'll help you figure it out. Brian Ogden says Moses isn't here. Fatty Caddy says this is not a watermark issue. It's not. And J-Rock, I agree. This shows a lack of attention to details. Yes. And Bama Law says they can hurry and amend if that's within what it is within 21 days of service from the feds. Well, at this point, Pxie needs leave from the court to amend because Destiny already served the answer. So he's going to have to get permission first. But I'm sure if they wanted to, they would get the court would probably grant leave of court to file. The case is very brand new. Nothing's happened yet. The earlier you are on a case, the more liberal the court is with allowing shit to. If it requires court's permission, they'll let you do it. Kia Patrick says, Destiny's affirmative defense is she's a hoe. Pretty much. She a hoe. Destiny's looking at those attorneys and they're like, your client's a hoe. And to be fair, his entire manifesto was Pxie's a hoe. Fatty Caddy says the watermark defense and the hoe defense. Genius. Yes. Groundbreaking jurisprudence. Ducky Fuzzer says, I want to imagine a home that has a Dale Earnhardt plate collection next to a Picasso. There has to be one somewhere. I would do that if I had the money for a Picasso. I'd put it next to some Dale Earnhardt plates. Jefferson Post says, I worked in a house where the roofers stripped the roof and didn't properly cover for the rain. It was a second home. The house was wet as heck. Yeah, it probably ruined the house. J-Rock brings up a great point. How is she going to mitigate being posted on porn sites? I don't think she would. I think she would try to say, did you tell them to take it down? Did you say I never consented to this. This is revenge porn. Because a lot of those sites, if you notify them, they'll take shit down. She could have done that. I don't know if she did it. I don't know if that'll really help in the 11th Circuit or if that's really going to help here, but I'd inquire if I was Destiny's attorneys. I would also say, you kept fucking talking about it. You made it worse. Now everybody knows. So those things happen, and they happen, and they happen. So there are ways she probably made this worse on herself. Will that be something that'll be something the court recognizes as a valid cause of action? I don't think so, but, you know, Destiny's kind of fucked, so you run what you brung, and can't make it worse. You can't make it worse. He's already fucking admitted to it, so you just keep going. Reapin' you suckers. Became a member. Thank you for joining up, doing your part to fight the Grays here. I appreciate your support and your generosity there in that regard. Thank you so much. Philip Martin says, can you recoup excess monies for the time you spent fixing the screw up? Yes, you can. And the cost of having to fix all of this, that's a recoverable cost. That seems unfair to you to make you spend your time and money fixing someone else's mistake. Yeah, no, that would entirely be something you could recoup. Because he took your money, didn't do it. Well, now I had to spend more money, so you now owe me my money back. Like, yes, you're entitled to all those damages, but you have to mitigate your losses. Fred Rush gifted 5 subs, chat. 5 subs out there. Got a couple people getting their subs out there. Doing their part. Are you doing your part? Are you doing your part to get rid of the Grays? I don't know, chat. You got to do your part out there, man. Got to do your part. But Fred out here, he just lined up and found those Grays and just... Fred saw those Grays and wasn't going to tolerate it. He wasn't going to tolerate it. Play the video, yes. EDW Raptor. He's doing his part with 5 more subs, chat. 5. Showing up. Showing up out there, chat. Showing up.
Fight for the future.
I'm doing my part.
I'm doing my part.
I'm doing my part.
I'm doing my part, too.
EDW Raptor's doing his part, chat. He's doing his part. So just keep that in mind. So let's see here. Dodging these green bullets like a gray Neo, yeah. Amateur Iconoclast gifted 1 membership. Thank you for gifting 1 sub. Appreciate the generosity. I appreciate it very, very much. And guys, if you did receive a sub, make sure you tell that person thank you very much. Really appreciate it. Travion Washington over on Rumble says, Destiny is a Me Too dudes. Yeah. Up on the horizon says, I meant I would have thrown stuff in the garbage, not the garage. Well, works too. It still works. Those people are all Grays doing their part in the clip, not dirty greens. Well, just because they blend in with you doesn't mean they are you. Natasha gifted 5 subs. Thank you, Natasha. Thank you for the support, your generosity. Praying the gray away. That's all we're trying to do here, chat. Just all you Grays, we're just trying to make it all green. It's just like Islam. We want you to submit. Robert Lawrence says, whoever thought years ago that would have been clipped for the lols. I know. And then Squizgar's coming in for 20 subs, chat. 20 subs. Oh, just coming in here doing his part, chat.
Was this story based? Yes.
Very base, chat. Very, 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 very base. Thank you, Squizgar, for your support and your generosity. Yes, the Grays, yes, Grays go down one by one. Yes. Natasha walks quietly down the street with her hat pulled way down low. Yeah, she's got her machine gun ready to go. Augusta Pinochet says, still gray, still proud. There's a chopper for you, my friend. Don't you worry. Me, Generalissimo. Hella says 50 Shades of Gay. Ooh, chat. She's calling you gay. Say gay. EDW Raptor says the greens are the fleet, the grays are the mobile infantry. I don't know. I'd rather been MI. I'd rather have been MI than the fleet. The fleet, like those guys died all the time. Those guys died in worse ways. Like the one lady gets chopped in half by the door. Like that seems like an even worse way to go. Because there's nobody standing over the top of you ready to just go like and just like drop you. At least in the mobile infantry, somebody could put you out of your misery. EDW Raptor gifting 10 sobs of his own. Just coming in to find his own way there, chat. He's tooling up, getting ready to come after you guys. Just keep hiding, Grace. Run. You know, you guys, we're going to run you over with our cars.
The CIA niggers glow in the dark. You can see them if you're driving. You just run them over. That's what you do.
That's how we get rid of you, Grace. We'll run you down with our cars. We'll run you down with our cars. Debbie says, I give some memberships, but have you noticed they are going to people not even in chat right now? Very sus. Who are those people? Well, Debbie, I'll say this much. I appreciate super chat. So the way memberships work, it's not even just people who are subscribed, but it's people who have been in the channel. So, for example, I've been gifted memberships when somebody's been live and I never was there. So like Robert Gavea, I've gotten a gift for his place and I wasn't there. I haven't been there when it got gifted. And I had to go back and look for it. But yeah, it's generally if you've watched it in the more recent time, you're eligible. So that's how that works. So I hope that makes sense. So it's not a problem there. Ag says, are we gonna watch F1 now or nah? Well, it doesn't start till midnight. But yes, at midnight chat, we are going over to potentiallycriminal.locals.com. We're gonna have an F1 watch party for the beginning of the F1 season, the Australian Grand Prix, chat. The Australian Grand Prix. That's right. The 2025 season is upon us, and it's gonna look great. I'm already excited. You know, it's apparently raining like a son of a bitch right now, but at least they're gonna drive. And I mean, at this point, it's looking good. It's looking good. We have an actual field, it feels like, this year. It's not just going to be Red Bull running away with it. I'm looking forward to it. Chat. I mean, really, like, this is going to be, you look at qualifying, like how it broke down. Like, I mean, here, the starting grid is McLaren is a 1-2. And then Red Bull is 3. Mercedes is 4. Ferrari, god damn, I'm a little disappointed. Ferrari didn't do so good. They're still top 10. But you have an Alpine in the top 10. You have a Williams in the top 10. There's great. Yuki Tsunoda's in the top 5. Like, this is great. This is looking good. This is going to be, I think, a good season, and I'm looking forward to it. I want it to be an interesting season. It sucks there's no Checo. I do miss Checo's not there this year, but that's okay. Yes, there ain't no sound but the sound of his feet. Brooks Euchre has been a member for 7 months. Thank you for the support, man. He's saying, I'm green, bish. Tax-free. But yes, chat, we're going to go over to locals, use the promo code WHIPIT, and we're going to hang out and watch the race. Yes, the mobile infantry is the backbone of the Federation. And don't you ever forget it. The White House released photos of Trump during the yeeting from last night. What? During the attack on Yemen? Because I don't know otherwise. J-Rock is saying, Hella's entire portfolio is in Australian steel stocks. She needs a subs, chat. Yes, guys, Hella over at Excited Utterance. Guys, she's there, does hearsay for days. Give her a look. Show her some love out there. Show her some love. Mad Reddick says, well, chat, Potcrim, enjoy your racism and have a good night. Happy Irish Christmas. We haven't talked about racism yet, but unless you're gray. But yes, it is almost St. Patrick's Day coming up. The Feast of St. Patrick. Maybe he comes back and drives all the fucking snakes out of Washington, D.C. Fingers crossed on that one. Fingers crossed on that one. So, the potato neighbors, yes. Has my camera gone into BB Mexico mode again? What are you talking about? It should, I don't think it's showing me white, but, well, it's showing me white. I don't know there. I don't know there. Anyone who plays the old Monolith FPS Blood, I'm debating buying on Steam. I already own Shadow Warrior and Duke Nukem, so I know building game engines. Okay. I'm just swarthy. I'm Sicilian. Yes, I do have some lineage back to the old country, but I also have lineage back to the islands. Keopathic says some judge is trying to order the president to bring back. Yes, the Venezuelans that the Alien Act does not apply. There's like I said, guys, we need to do a Trump show. We might do that on Monday. A lot of stuff is brewing. There's a lot of stuff brewing with immigration coming up, so we'll take a look at that here. Quake 4 did not work above 1080p. Wow. Yes, the Blood is regarded. It's very good. It's very good. It's very, very good. The Blood series is great. Real quick, I'm going to make sure I got this right. Shredder S says, gifting 5 subs. Shredder, thank you so much for your support and your generosity. Very, very much. I do appreciate it. Brooke says, when will the impeachment start? Never. I don't want them to start because you need 60 votes in the Senate to convict. And you're not going to get those. So doing the impeachment would be retarded. So I don't want to do that. I don't want to do that. You said so many courts are talking about Trump failing to follow the courts. I'm losing my mind. Remember, they're the judicial. The courts are the coup right now. They're the baddies. Oh, yes, just shredding those grays. Yes. All right, chat. So that's it. Like I said, there aren't any, world-beating issues here. There are some I have a lot of concerns about for Destiny. And if I was his attorneys, from a simple penny lawyer, you guys might want to fix some of this stuff. I think there's problems. I think they're problems. Do I think that they're fatal? Potentially. But I think you're in a situation in a time frame where you can fix them and no questions asked. So I would definitely take care of that. I would take care of that. And then chat, look who comes crawling back to us. Look who comes crawling back to us. Augusto Pinochet. Mi Generalissimo joins the ranks. Glad to have you, sir. Glad to have you, General. Glad to have you. I didn't want to throw you out of a helicopter. New channel, potentially fatal. I can show all the Indian people running into power lines with metal poles. That'll be great. Jefferson Post, we're going to end on this. He says, no, Sean. Destiny doesn't mention beating in relation to Destiny. Don't do that. Yeah. Squizgar says, out here just slotting all these gray floppies. Yes, chat. If you don't know what slotting floppies means, that's a term from the Rhodesian War. Slotting somebody is the British term for, and when you'd shoot the guerrillas as they infiltrated, well, they would flop around. They were also called floppies because they were flip-flops, but mainly when you shot them, they'd flop all over. So that's what the Rhodesians used to call the guerrillas, the commies they were killing. So, guys, with that said, I will see you guys shortly over on Locals for the F1 party. Yeah, that's it. That is it. I think we did a pretty good job with this tonight. So remember, chat, until next time, just because you did it does not mean you're guilty. Although, Destiny, I still think you're liable as fuck, brother. you need to be working on how to settle this. I really think you need to be working on how to settle this, unless you've got some secret trick up your sleeve. And if you really had that, you would have played it by now. So I don't think you do. But I am glad your attorneys, you finally hired some attorneys, and they're finally here in the fight. I am proud of you for that. So, you know, good job. Good job on that part. Real quick, Debbie O, it's a good question. Could you get rid of all existing federal courts and then create new federal courts and renominate all new judges? Yes. If you were able to successfully abolish the current judiciary acts and then pass a new judiciary act, you could then reinstate all federal courts, every district court, every circuit court, every court of claims, every court under Article 3 could be wiped out and restarted. The only person you could never get rid of is John Roberts. So even then, you would appoint all 93 federal circuit district courts, all the circuit courts, and then you'd appoint all eight of the justices. You'd be able to appoint 8 justices. So yes, you would 100% could fucking do that. That would be literally insane, though. Like, I mean, like, don't be careful. Be careful. Like you tread on my dreams when you say those things. So, but yes, that's a very good question. You could do that. You could do that. That would be crazy as hell, though. I would be laughing forever. So, all right, chat. So we are going to wrap this up here. Like I said, I will see you guys over on Locals. But yes, if you're Destiny, dude, you need to fucking settle. This is not going to help you. So, chat, good night and take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick hated yelled at?